exercise. So the ultimate question is, if we continue, we are looking for a contrary indication, and you will interpret Section 9 and this Act in accordance with the provisions to give effect to voting rights, not to take it away. Of course, it's limited by its context and its actual wording, but that is the strive, purposive, not destructive, as our learned friends tend to do. Now, what will then be an indication in legislation of a contrary intention? We often find, my lords, for instance, that the legislation will say, if you've made this decision, it's final. You find that in tender legislation. It's final. So then, once that finality, which is a principle of functus officio, is indicated, then it would be a contrary indication. So then you cannot apply Section 9. The best example of a contrary indication in this Act, your Lordships will find at Section 78. What was the section you gave me, Eliasa? The one on death? Sorry, my lord. 97. That's possibly the best contrary indication where the President cannot exercise the right under Section 9. 76. Sorry, my lord, I did make a note. Oh, here it is. 76 talks about lack of nomination or death. And it says, if, and your lordships then go to B, a duly nominated candidate for the election of the President dies or becomes incapacitated. That's Section 76B. Then there is only one option. If it is before the poll for the election has commenced or while the poll for the election is taking place, the Commission must immediately terminate the election and all proceedings, and then it explains. So if the President in those circumstances issue an extension or amend the original proclamation, that would clearly be contrary to a contrary indication in the Act, or where the Act said something was final. Now, I will now turn, if your lordships then go to Section 63, and all these sections will indicate to your lordships that the President may do or may have done what he did. Now, 63 speaks about a general election must take place, and then A, for an election of President, on a date not earlier than 5 months and not later than 3 months prior to the date on which the term of office of the President expires. And we know the President says, and that's not in dispute, that his term will expire on 21 March. So the 5 month back is 21 October of last year, and the 3 months backwards is 21 December of last year. Within this menu of 3 months, an election could take place. And so it is not, of course you must do it before, you must say before that comes, there's nothing in it. You can't do it afterwards if the day is gone. So it's not the word before means nothing. It's a neutral word in this context. So it kicks off with 63. Then you move, with respect, my lords, to 64. And it then says, if a general election is to take place in accordance with Section 63, in other words, within those period of 5 and 3 months, amongst others, it must by proclamation in the Gazette make known. Now, the word before is not in there. That they get from Section 93, which I will turn to in a moment. And then it says, in case of such election, sub 1 for the President, and you skip 2 and 3, a date determined by the President upon recommendation by the Commission upon which the submission of nomination of candidate must take place and the place at which it must take place. Your Lordships can insert there at page 327, 16 October last year was that date, 3 to 7 of the record. Then it says in 2, despite anything contrary to in this Act, which then deals with the outside Namibia stuff and so forth, and then it says, before the polling day determined, therefore, upon which poll must be taken place. And your Lordships will see if you turn the page, it then says in sub B, subsection 1B, must be a day not less than 40 days and not more than 45 days after the nomination date. Now, if your Lordships count, and that is also common cause, from 16 October, the period 26 November to 30 November fell within that period. And so the 27th of November was within the menu for the election to take place. And you could extend, so to speak, without not complying with the provisions, taking from that menu until the 30th. And that is exactly what the President did. But more importantly, or also importantly, it says in sub 6 of 64, any day determined under 1B for an election of President is a public holiday. It doesn't say must still be declared a public holiday. It says it will be. So when the President made the extension and the 27th, those days were public holidays. And it is only the President that can do that. So if you're in the queue, for instance, 1993 3Q, so to speak, and you run over for 2 days, which is permissible, then the President can simply say, I also publish those days to be part of the election. And that will then automatically be public holidays. No contrary intention, nothing. So if one can continue then, where
of the sense in which that provision of public holiday can be of significance. Say somebody was dismissed for not having gone to work on that day. He's a civil servant. He can say, no, you couldn't have dismissed him.
Yes, exactly, my
because they are deemed not to have been at work.
Yes, my lord.
Yes, okay.
Well, we're coming to the this deeming thing, which they haven't mentioned. It's almost like a silent accession coming. But we come to the deeming provision. Now, 93, my lords, is simply a statutory provision of where, if there is a day or days published by the President, those will be the hours. It's not for anyone to change it or reiterate it or whatever the case may be. I will show your lordships, and they are quite correct if they refer to sub 2. It says the Commission, not the President, may alter by notice published in the Gazette at any time before the commencement of the poll the polling hour referred to in subsection 1A in relation to that was done, my lord, never. The polling hours never ever were changed. They always remained as they are in terms of section 93. The Commission never changed the polling hours. What they did do is what they explained in respect of those mobile stations. But that they did, and there's no complaint about that. But once those hours were made known, those were the hours which were applicable on 29 and 30. The President didn't change anything, let alone I hear again that he's changed the polling stations. He didn't. So, but importantly, also in the provisions of the Act, I must take your Lordships back to section 64. 64.4, which is also a powerful indicator that nothing indicates the contrary. It says in sub 4, an election is deemed to commence on the day stipulated in the proclamation referred to in subsection 1, which is published in the Gazette. Now, importantly, sub 4 only speaks about commencement. It doesn't say when the election will end. If it said it will also end on the day originally published by the President, then there would have been a contrary intention that he may not use Section 9. But in fact, the contrary appears, that he may use it, read with 1-2 of the definitions. Then, my Lords, 94 is a very, very powerful indicator what may happen, which is not a contrary indication as envisaged in Section 9. Now, if your Lordships are with me, it says 94.1, the presiding officer and other officers at the polling station assisted by police officers must. If you then go to sub 5, and that says what they must do, and then sub 5 of 94 is crucial. It says, despite anything to the contrary in this Act or any other law, despite anything. And it says, a presiding officer who is of the opinion that there exists at the polling station a situation which threatens, and A, B, C, your Lordships can read, but F is crucial, the taking of the poll thereat to the extent that the objects of the Act cannot be achieved. If he forms that opinion, the Act makes very plain, he or she must forthwith discontinue the taking of the poll and close down the polling station, whereupon poll must be taken at a time, in the manner, in respect of the voters, as may be directed by the returning officer concerned after consultation with the Chief Electoral Officer. 6. The powers conferred by this section has got only one prohibition, and that you may not exercise it so to prevent any voter who is entitled to vote. Now, my Lords, the issue was not in this case that any electoral officer may not have used this. But this is not what we say happened, because it's not an issue on the papers, but what this is a powerful indication that in those circumstances, the President may, if it is recommended to him, if the electoral officer said, we close down, we're going to open on the 30th, and the ECN said to the President, we recommend that you also publish the 30th as a day on which this election, now in its extended form, shall take place. Then there would have been no ways that the President would act unlawfully, even if there was a breach in time. Even if they're so fixated on contract law that you cannot extend something which came to an end. Why not? If the power is there and you extend it, then you extend it, even if it's retroactive or retrospective, because they're not complaining about the retrospectivity for a good reason. No rights were taken away retrospectively. Rights were given retroactively by the President. So again, this is a powerful indication that Section 9 does not indicate anything to the contrary. Then, my Lords, can I just not deal with 115 for the moment, but we then come to section 204. Yes, it's in there. Your Lordships haven't heard that number today for very good reason, but let me read it to your Lordships. Now, 204 is a new section. It has not been in any section of any act before. And one can understand why the legislator did that. Because of the rumor mongering. Because as soon as the writing is on the wall and every agent in the field sends the results on the wall through, you quickly do your calculations and say, oh, I failed again. Let's just start complaining and look for reasons to challenge. And let's feed the nation with false fact. And that is what always happened. Your Lordships will read in every judgment, and your Lordship, Mr. Justice Damasep, in the RDP matter, which is reiterated by the Supreme Court judgment, actually said before, guys must come with facts. Stop the rumor mongering. And again we have that. And it is time now, on these facts, it is also permissible to say, now you're paying the cost. Stop it. If you have valid complaints, then you come to court. If you read the entire act and you can comply with the entire act and you've got a valid complaint, then I will, and the court shall, I know the court will, then accept, and if it is necessary, set aside. But then you bring facts, not political statements and labels, what we read about in the founding affidavit. Now, paragraph or section 204 says, an occurrence book is to be kept at every registration point, polling station and collation center, in which, then it deals with three things, in which all complaints, events in which a person is dissatisfied, and incidents are recorded and signed by any person present as a witness. But any event or complaint, now importantly, my Lord, it does not now speak about an incident, because an incident seems to be an immaterial little thingy, that is not recorded and signed for in the occurrence book is deemed not to have occurred. But even if you've got it in there, and the burden of proof lays with the person alleging the occurrence of the incident or complaint. So now incident is put back, so, and the complaint. So, but the point is this, as threshold, because of all the rumors and the like, it is the legislator said, from now on, having read, I suppose, all the previous judgments, from now on, we're going to put a threshold. The facts will not be justiciable if it is not in the occurrence book. And you read it and you comply with it. Now, there is no dispute that the occurrence books were kept, and there's also no dispute that not a single one of these complaints today before your Lordship as to voting on what they call days that shouldn't be voting days, is in an occurrence book. What the LPM does is to say, well, I've got a clever idea. This occurrence book does not deal with ultra-virus provisions. But with respect, my Lord, Section 64 is in Part 5. So if you voted on the 29th and the 30th, and there was an ultra-virus act, then you had to record on the 29th and 30th because you were there. So what's going on? I see people voting here on the 29th, we must record it. Why did they not record it? Because they asked for it. But when, alas, again they lost after that, then suddenly they say, I asked for it, but where do you get the power from? By the way, that's what they do, and I will refer, and your Lordship, Mr. Justice Damasep, did not indicate anything but asked the question, is this relevant, what they asked? I respectfully submit it is. Because if you look at section 172, which brings us to this court as well, then, is it 17? Yes, 172. Now, the presidential election challenges. In any election of the president, any challenge relating return or outcome of the election. Now, your lordships dealt with that in detail in the Itula case. This kind of complaint, the Itula case says, will also include any other like what we have here. So 172 takes you to 204, because what they now say is this 172, our complaint, ultra vires complaint, is not really a 115, but that's wrong. The Itula case already rejected that, because you must go through 172 to get to this court. Now let me say this, my lords, with respect. If you look at the provisions of the Act in Part 5, every non-compliance conceivable by anyone contained therein will be an ultra-virus act, either by commission or by omission. If the polling officer stops someone to vote, he would be acting ultra-virus. If he stopped 500 people to vote, he will be acting ultra-virus. If he allows 9,000 to vote on 29 and 30, he will be acting ultra-virus, but it must go into the occurrence book. And this is so important. My lords, recently we referred to the judgment which was penned, and I hope I give your lordship the right credit now, Mr. Justice Damasep. You wrote the judgment on the deeming provision in the case about the provisions in the Public Service Act. And there your lordship set out actually correctly. We submit in the circumstances of this case where there is no complaint that no one could get to the occurrence books at any of the time, that they couldn't insert it, that is the end of the inquiry. And nothing can be justicable. And we submit indeed, my lords, that it is an irrebuttable presumption which is created. If your lordships, and one cannot always give everything that you research, any evidence. Now, sorry, my lord. Oh, so he says he's just giving me my book. Now, my lords, I must finish, but may I say this? So the road goes like this for a valid challenge. It goes through 204, through 172, and then you come to 115. I don't have time, my lords, to deal with this bundle of authorities which I've handed up on onus. May I just say this in short? Every case that dealt with onus in this court is in here. I have, before I made the copies and the numbering, highlighted the portions for your lordship. I apologize if there's some pencil marks. That is just how my law reports look. And so your lordships will find that in... I beg you.
Those markings are not meant for us, in other words. They're
not
meant for our eyes.
No, it is, your lordships, it's just highlights and pens. It's not writing. But they've got the same. What I want to just suggest to your lordships is what we submit the test is. And what the Patter versus Tai case, which is the first case in the bundle. Now that case was pivotal in the judgment of the full court of Mr. Justice Damasep, Maritz and Tambanengwe in the Republikaanse Party case, which eventuated in a recount. And in that case, my lords, the full bench made with reference to the old cases, the English cases, also the one of Lord Denning, and so forth. They are all in Pater, so it's nothing new. And what the Supreme Court did, the full bench did, was to, at page 11 of that bundle, that portion in the middle, the bundle is marked right-hand top. And Pater versus Tai, it says, passing to the owners, this is Justice Tyndall speaking. Remember, my lords, this is a case for application for leave to appeal, which was eventually dismissed. It seems to me clear that once it has been shown by the petitioner that a non-compliance with the provisions of Chapter 3. Now, your lordships will see that in those provisions at the time, there was also a distinction made of the provisions of the Act and the principles of the Act, as it is still today. It says, the onus lies on the respondent to prove that both conditions mentioned, what they call the curative sections, have been satisfied. But this is what was quoted and eventually came into the full bench and into RDP, and of course in the Itula case it was corrected a bit, although the Itula case didn't head-on deal with owners. So, but this portion, I just want to point out to your lordship, is misleading if you only quote that portion, or can mislead the reader rather. It's not intentionally misleading. Because Mr. Justice Tyndall was dealing with this issue of the Act as it was then, and for that I must refer your lordships to page 8 of that bundle. And you will see I've highlighted the first portion, and I start at the second sentence, and he's now discussing the provision which is quoted on the previous page, the old section 91, no election shall be set aside by reason of any mistake or non-compliance with the provision of this chapter if it appears to the court that the election was conducted in accordance with the principles laid down. So it's non-provision, all those little ultra-virus principles. But then he discusses at page 8, he says it is not reasonable to construe section 91 as relating only to such relatively unimportant non-compliance with the provisions of the chapter as do not in any degree infringe the fundamental principles of the election by ballot, and in that case was on secrecy. That being so, when the section says, if it appears to the court that the election was conducted in accordance with the principles laid down in the chapter, it must mean something different from if there has been non-compliance with any provision involving a matter of principle.
As to the relevant
Yes.
pages,
So,
we can look it up for ourselves.
Yes, thank you, my lord. So I would submit, may I just finish, my lord, I know.
You were out of time, I'm afraid. But you can address us on costs.
Yes, my lord. I respectfully submit. Can I just hand up then the reinterpretation of statute, which I won't read, but that is in relation to when a proclamation comes into force. That is our section 12(2) and 1.
Any sympathy for us, because you keep on providing us with more reading, bedtime reading, as if we have not read enough, even towards the
But
end.
there is still this. So all it says that is when the date of the proclamation is the date which you will read from the previous night. So there's any event, no break in anything. As to costs, my lord, I respectfully submit that this application of both these parties should be, the dismissal should carry with it a cost of, in our case, 1 instructing and 2 instructed counsel. It is not. It may have been different if we didn't have Itula. But if you have Itula and the court has spoken on the test, And in that paragraph 85, it says that even if there was substantial non-compliance with anything, then still it's remedy issues. And they should have they knew, my Lord, that this is completely unnecessary. There will not be a difference. The results were made known beforehand and again, and they continue. And for those reasons, and also the remarks, mostly as far as the President is concerned, Mr. Swapo, why does he say, not only in his notice of motion, but in his affidavit, that the President acted mala fide? I respectfully then submit that the application should be dismissed with costs for both parties.
Very well. Mr. Narib, then, please.
Thank you. Hello. Your Lordships, at the outset, I wish to submit that we will not persist in the point relating to the authority of the LPM. Mr. Swartboy, who was a candidate in the presidential election, is before court, and he has the standing to be here, so that obviates a need to decide the question of authority of the LPM, because it does not take us any further. And that issue of authority of LPM is also squarely raised in the court below. It is a live issue. And it has got real consequences for the decision of the court below. So we will pursue that matter in the electoral challenge before the electoral court and not here, because it is not dispositive of this specific application. Okay. Now, as far as the application for joinder is concerned, we only make one point. We have taken note of the authorities that are referred to by LPM. Your Lordships, the only point we will make is Rule 7, Sub-Rule 17 of the rules of this court. Rule 7, Sub-Rule 17 of the rules of this court provides for how a party to the proceedings, that is, a party that is cited, can become an applicant in those proceedings, and that rule clearly provides for the timelines within which that has to happen. So the rule provides that in such event, the applicant must bring a counter application, and that affidavit must be filed together with the answering affidavit. Now, I hear what the submissions on behalf of the LPM in this regard. if the court is to accede to those submissions, we say that the control that the court has under Rule 17, Rule 7, Sub-Rule 17, or 17 of the rules, insofar as the timelines within which the papers have to be filed have to fall away. And then it becomes a normal application for joinder with its own timelines, and also the provisions of the rules relating to the filing of the pleadings then become in
Is it the ECN's case, LPM should not be part of it? In this case, forget about everything that they have placed before. Is that the bottom line of the ECN?
No, Your Lordship.
So that we can really decide what is our important issues.
I want to add on to what the DCJ has put to you. I found it quite strange that the ECN is engaged in this type of point-taking when it's an impartial, independent body. I would have thought the duty of the ECN is to put the facts before the court and let the different protagonists argue them, and not for this kind of point-taking by the ECN.
It is not.
Having acted for the ECN myself previously on more than one occasion, that's certainly how I felt that it should be done, and also not engage in name-calling and that sort of thing, in keeping with the type of independence and impartiality which is supposed to come with the ECN, and accountability.
Just add, as a public body, I thought ECN's duty is to assist the court.
The ECN is trying to assist the court, Your Lordship.
And not to really engage in antagonistic litigation. This taking small points like the one that you have just now abandoned.
I hear all of that, Your Lordship. Only thing that I'm saying is take account of Rule 7, Sub-Rule 117, Sub-Rule 17 of the Rules of Court. So if the court is content, or if this rule does not raise any concern to the court in relation to how a party becomes a joinder.
We want to know your bottom line. Is it your bottom line? Chuck them out, forget about everything that they have said, and decide the case on the basis that they have not participated. Is that the ECN's bottom line?
If that is the import of the rule, Your Lordship.
Sorry?
If that is the import of the rule.
I see. Okay.
So, but if that is not the import of the rule, then we can, obviously the court must admit them and we must proceed. So that is the only point I'm making in regard to that. The next aspect I will deal with, Your Lordships. Actually, this is the main submissions on behalf of the ECN. There are two particular aspects that I want to deal with. The first one relates to the processes and the returns at polling stations which have not been challenged. The principal submission there will be that at least a substantial portion of those returns have to be challenged for one to be able to upset the announcement of the results. And the second part of my submissions will relate to what we refer to as the principle of subsidiarity in the context of the application of sections 115 and 204 of the Act. May I just quickly move over to the question of the returns. Your Lordships, we have referred the court to the powers of the returning officers and the presiding officers as they deal with, as they conduct the elections. Section 110, subsection 5 of the Electoral Act. May I just refer to that? No. Perhaps I can start with section 105. Subsection 5 of the Act. It reads, the presiding officer must, in the presence of the persons referred to in subsection 1, endorse word rejected on any ballot paper rejected in terms of subsection 3. And then subsection 8 of that section. When counting of the votes have been completed by the presiding the presiding officer must cause the counting agent present to record their presence in the prescribed form and manner as proof of presence of the counting, announce in the prescribed manner the return of the count, inform the returning officer thereof, and post a copy of the result at the polling station concerned. But in the case of a mobile polling station, the results of all the polling stations for that mobile polling station must be posted at the closing of the poll where the votes are counted. And then section 109.
In their case, they say the ECN gives a directive late on the 27th, which directive starts a process which leads into a proclamation passed by the president to extend the voting, and that's the unlawfulness. Where do these things of the returning officers and what come in? They are challenging that action of extending the election. Now, what difference would it make if they cited returning officers? They say that which led to the extension is the unlawfulness.
I get that, Your Lordship. We are not saying they should have cited the returning officer. What we are going to submit in fullness of time, Your Lordship will see, is that under section 115, Your Lordship, if there is no proper challenge to the returns such that it shows that the elections were not conducted in accordance with the principles, the court cannot upset the elections. So I'm building to that proposition that I will deal with when I deal with the subsidiarity principle. So what I'm submitting is that insofar as the returns are concerned, there are certain decisions that are made at the polling stations by presiding officers. Those decisions lead to the publication of what is called the Elect 37 form that is pasted on the wall. And under section 204, everyone is provided with the facility to record any let me call it mistake or non-compliance, because that's a wording of Section 105. But Section 204, as my learned friend submitted just now, deals with the recording of the occurrences, events, perhaps irregularities, or even illegalities at each of the polling stations. So once you have Section 204 requiring the recordal of those irregularities, illegalities, fraud, whatever, at a polling station, it creates an opportunity for you to challenge a specific return. Okay.
It was issued in a polling station. It was done at the Electoral Commission headquarters.
Pardon me, Your Lordship.
I said the directive was not issued at the polling station. It was done at the Electoral Commission headquarters and the proclamation signed at the State House.
Yes, Your Lordship, but the return was made at the polling station.
But I'm sorry, Mr. Narib. I'm unable to follow exactly what the line of argument is. I mean, what is the point you're trying to make here?
What I'm submitting
if you
is
can summarize your submission, perhaps to make me understand it better.
Yes, each and every return is made pursuant to the powers that are conferred on presiding officers, and they make administrative decisions. And those returns have not been challenged, they stand. And those returns are the ones that inform the final results that are announced by the chairperson. And the Act provides for an opportunity or the process by which you can prove each and every one of those returns wanting. And that is provided for in Section 204. Okay. So, without those returns being challenged, they exist as a matter of fact. They have a record of the votes that are counted at each and every polling station. And those are the ones that are collated for purposes of announcing the results. So on Odegrau they stand.
That's the 4,699 of them.
Yes, Your Lordship.
So they should have challenged each one of them.
Not each one. Sufficient number on Section 115. Not each one. Because the threshold is set in Section 115. Now, let's look at Section 115. Your Lordship, I think I can move quickly to Section 115. And this submission was made by my learned friend for the President. No election may be set aside by any competent court by reason of any mistake or non-compliance with this part. We know from Itula, paragraph 85, that this is a prohibition. No election may be set aside by any competent court by reason of any mistake or non-compliance. So, the first part of that section assumes an established mistake or non-compliance. The first part of it, it says any, so it does not qualify the mistake or non-compliance. It does not qualify it at that stage, but it assumes that there is a mistake or non-compliance and yet prohibits a court from setting aside an election. And it says, it provides a condition. If it appears to the court that the election in question was conducted in accordance with the principles laid down in Part 5. Now, as my learned friend for the President submitted, it should then be clear that non-compliance with Part 5 is not equal, or may well not be equal, to not conducting the elections in accordance with the principles in Part 5. It's not the same thing. So if there is a non-compliance or any mistake in Part 5, that does not, by that very fact alone, equate to the breach of the principles, because even in those circumstances, it may well appear to the court that the election was conducted in accordance with the principles. And then there is a conjunctive and, as representatives of the applicant submit. And the mistake or non-compliance did not affect the result. So if it is conducted in accordance with the principles and the mistake or non-compliance did not affect the results, the court the elections. It is prohibited from doing so. Only instance where the court can consider setting aside the election, and this is also where Itula takes us, the judgment of this court. Only instance where the court can consider setting aside the election is when the election was not conducted in accordance with the principles and the mistake or non-compliance affected the results. Then there is that discretion to set aside the election. Now, Your Lordships, it is important not to equate or not to elevate the principle of legality outside or the scope of the reach of this section, because the section itself subsumes legality. It subsumes it by the assumption in the unqualified statement in the first part of the section, without a qualification. Without a qualification. The only qualification there is to a mistake or non-compliance is when the court considers whether it affected the results. So the principle of legality cannot sit outside the reach of Section 115 because the section itself says so. Because a mistake or non-compliance, by its very definition, must be a various issue. Because once you say you don't comply with Part 5, you must be saying you've failed or you've breached one or other of its sections. Yet, even in those circumstances, the court is still to consider whether the election was otherwise conducted in accordance with the principles in Part 5. So, Your Lordships, I must disagree with my learned friend for LPM to elevate the legality question outside the scope of reach of Section 115. It is subsumed in 115. This is the context within which the principle of subsidiarity arises in our respectful submission.
The governors of Namibia sit somewhere and declare an election that comes within 115.
Pardon me, Your Lordship?
If the governors, 14, I think at the moment they are 14, sit somewhere, they decide there must be an election, or they extended the election, that falls within 115.
If they declare an election invalid? Or
They extended the election.
if they extended the election?
So we governors, we were disappointed. Most of our people did not vote. We are extending the election. It falls within 115.
Your Lordship, would Your Lordship still be able to find in those circumstances that it was conducted in accordance with the principles under 115?
Well, I'm asking the question.
Isn't it?
Yes.
Yes.
Yes, Your Lordship.
And that's what we, according to the submissions that we've read so far, that we are, that has brought us here.
Yes, Your Lordships. If the governor somewhere decide to extend, I mean, Your Lordship is testing my proposition. If the governor somewhere sits and decides to extend an election, Your Lordship will immediately find a mistake or non-compliance. Yes,
Okay.
Immediately. Your Lordship will say Section 64 confers the power on the President to set the date of election, and not on a governor. Section 64 is in Part 5.
Remember, Mr. Narib, 115 says, unless it affects the outcome.
They are conjunctive, Your Lordship.
I think I got my answer. You said it's fine.
Yes.
It will go to 115. Meaning, if the result would not be affected, the declaration by the governors will stand.
No, Your Lordship.
Oh, I see.
That is not what I'm saying.
Oh, okay.
I am saying 115 has got conjunctive requirements. The court is prohibited from setting aside the election if it was conducted in accordance with the principles of Part 5. Okay. But if it was not...
For me, that is not a mistake or a non-compliance. It's a vandalism of the Constitution. That's vandalism. You can't do that. So don't even try to take it to that territory. I'm surprised you persist that it's a sort of thing that goes to 115. But I think I got my answer.
You will answer when you return from the break. We'll take a break for 20 minutes. We resume at 1600 hours. Would that be convenient to do so, Mr. Narib, at this point in time?
Yes.
Okay, very well. The God will adjourn. Yes, please, Mr. Nari.
Thank you, Lordship. Returning to the question that was put to me by His Lordship, the Deputy Chief Justice. Seems to me the question is testing the limits or the reach of section 115 of the Electoral Act, and whether it is constitutional, if it is to be understood in a manner that I'm submitting its wording is. Your Lordships, this section is not challenged before this court. It stands as law that was passed by Parliament. If its import is as I submit, that mistake or non-compliance in the first part of the section is assumed, and in those circumstances the court is prohibited from setting aside an election if the election is in any event conducted in accordance with the principles of that part. And the mistake or non-compliance did not have an effect or did not affect the results. If the question is whether that provision is consistent with the Constitution, that is not before us, before the court today. The true question that is before the court is whether the President could have done what he did on the facts of this case, based on the recommendations of the Commission, because of issues that arose during the elections, where it was established that some voters at specified polling stations may have been deprived of the right to vote, whether that action of the President of extending to allow for those voters to vote on the 29th and the 30th, if that is found to be unlawful, then what is the import of this section? What does section 115 say in those circumstances, where the President announces the 29th and the 30th to be polling days? And this court says the President did not have the powers to do so. What does section 115 say in those circumstances? That is the various question that is arising here. And section 115 in my respectful submission says, Your Lordships, that the court must still consider whether the mistake or non-compliance, or whether the election was in any event still conducted in accordance with the principles, despite the breach of the sections, despite the breach of section 64, 1B, whether the election was in any event conducted in accordance with the principles in terms that are in Part 5 of the Act. And if it appears to the court that indeed eligible voters were afforded an opportunity to vote, it was a transparent process. The party agents were allowed to observe. The results were posted on the site and the like. The court should not upset the election. Actually, there is a prohibition to do so. So that is the context within which the question arises. Of course, Your Lordship, I submitted earlier that if a governor extends the election, the mistake or non-compliance would certainly be established because the governor is not even named in Section 64. But if the governor extends the election, or announces the dates of the election, my submission will be such an election cannot be found to be in compliance with the principles of Section 60 of Part 5 of the Act.
To the next point,
Yes.
Mr. Vice. I think you have to make economic use of your
Yes.
allocated time.
Yes.
We don't want to sit until late. You remember what was agreed in chambers that we must finish today.
I'll move on. Just returning to Section 204 of the Act, the judgment that my learned friend for the President referred to is the Minister of Finance versus the Labour Commissioner and others. We cited at paragraph 31 of our heads of argument. That is where that fiction, in our respectful submission, the irrebuttable fiction, is referred to. Now, my respectful submission will be that for there to be established a mistake or non-compliance such that it affects the results, affecting the results in the sense that the outcome of the election could perhaps be different. One has to pass through these two sections, Section 204, to establish the mistake or non-compliance, and Section 115 for the court to apply the test they set out. And in accordance with the principle of subsidiarity, we submit that if Section 204 or Section 115 are constitutionally wanting, it is not incumbent on the applicants to ignore them, but to bring a frontal challenge to these provisions. As we have submitted earlier, the provisions or the legality principle in our respectful submission does not sit outside the scope of reach of Section 115, because that is the very thing that the section assumes has happened. On the principle of subsidiarity, as early as 1995 in Kawesa, this court had said that constitutional law should be developed cautiously, judiciously, and pragmatically. If it is to withstand the test of time, it endorsed the well-settled practice to decide no more than what is absolutely necessary for the decision of a case. Now, in this case, our respectful submission is that the facts are governed by these two sections, 204 and 115 of the Act. And we submit that the applicants have not brought themselves within the purview of those sections. And the normative position then is that the court should not upset the elections. In road fund administration, a case we cite in paragraph 44 of our heads of argument, this court had said that the Constitution must be the last and not the first resort in resolution of disputes that come before court. I say that point in time because intuitively one assumes or one accepts that the Constitution is the supreme law. In Kawesa, in Atchison, it was stated in the High Court in S versus Atchison 1991 Namibia reports at page 10. The Constitution of a nation is not simply a statute which mechanically defines the structures of government and the relations between the government and the governed. It is a mirror reflecting the national soul, the identification of the ideals and aspirations of a nation, the articulation of the values that bond its people, and disciplining its government. The spirit and tenor of the Constitution must therefore preside over and permeate the processes of judicial interpretation and judicial discretion. Now, if coming from that perspective that was already articulated in 1991, it was rather startling for some of us to hear that the Constitution must be the last resort, but it is because, in my respectful submission, the principle of subsidiarity was then not well understood. It is counterintuitive to think that a constitutional norm must be subsidiary or secondary to a statutory norm. And that is why instinctively one resorts to the principle of legality and asserts, in my respectful submission, that since it is a constitutional principle, non-compliance or with it must, in this specific case also, result in a declaration of unlawfulness or setting aside of the elections. But if the principle is properly considered in its context, and one brings together the notions or the dictum in Atchison with the dictum in road fund administration, what the principle seeks to achieve is rather simple. The Constitution still presides over all judicial thinking, on all judicial processes, but it is sitting, it's perched on top the subsidiarity doctrine dictates, in my respectful submission, that whilst the Constitution remains the supreme law, and whilst it provides for, or while its processes must permeate all judicial thinking, these normative positions that are created pursuant to the provisions of the Constitution, and in particular, the principle of separation of powers, conferring power on the legislature to make laws for this nation, requires of this court and of all the courts to respect and uphold the will of the Parliament until pardon me, Your Lordship?
Parliamentary supremacy, or what is it?
No, Your Lordship.
What are you trying to convey?
No. Until that provision is challenged. It is not me saying so. It is this court that said that in Gondwana Collections. In Gondwana Collections, this court said that when let me just find it. When an enactment is made by Parliament, prima facie it represents the will of the freely elected representatives of the people. I'm trying to find the quote. Oh, paragraph 49 of our heads. Where legislature has provided for specific procedure for the ventilation of legal disputes, it is to that procedure that the public must have recourse in the first place, and not the Constitution. If the procedure is found wanting, viewed from the prism of the Constitution, the appropriate thing to do is not to skirt the applicable procedure, but to challenge it and have it set aside. That is the principle of subsidiarity, which guards against flourishing of parallel systems of law. That is Gondwana Collections judgment that we cite on page 17, paragraph 49 of the heads of argument. So it's not parliamentary supremacy, it's separation of powers.
Point, Mr. Nari.
Yes.
Now, just interjecting to test your argument.
It's Your Lordship, it's separation,
really
separation of powers. So, also, same proposition in paragraph 48 of our heads of argument.
To get to the facts of this case. When we go out of here, we must go and sit and read through these affidavits and decide. Mr. Narib, I want to understand something at paragraph 93 of the affidavit of the... We're citing the law. We know the law. 5 of us here, I think you should assume we know the law. So you tell us too much about the law. We want to get to the facts of this case. Paragraph 93 at page 283 of the affidavit of the Commission. I really want to understand what they are saying here. Some of the polling stations that were not affected by the shortage of ballot papers proceeded with counting upon closing as required under the Electoral Act, and others remained open. When they were open for what purpose?
There were 2 purposes, Your Lordship, and yes. Those also set out in the affidavit. I will find the references. One purpose was to allow for exchange of ballot papers. Because once you close, you have to account for the unused ballot books. I think that is Elect 36 form. And you have to account for it as the presiding officer. So if you have to transfer it to somebody else, that person has to account for it.
Yes.
So you could not close if you had to provide ballot papers to those polling stations that were in need. So that's one reason.
So while that process was going on, no counting took place, and as I understand it.
At those polling stations that would provide those ballot books. And then the other reason was that in terms of, there were still people in the queues at some of these polling stations. And those had to be attended for as required by Section 93, bracket 3 of the Act. So you could not close while you have people in the queue. Then some of them obviously had to wait to receive some of those ballot books to continue with the voting.
Two questions. One, what is said in paragraphs 93 and 94? Your understanding of the case. Are those allegations disputed?
No.
That's the one. Number two, again, understand in relation to the people in the queue. Those who were not in the queue, how did the ECN define that cohort of voters? How do they know who these people are?
There were specific complaints, Lordship, and that is also explained.
By whom?
There were complaints that were received, or there were discussions with the presiding officers.
Yes.
So that's also set out in the affidavit. They received the ongoing discussions with the presiding officers on the 27th, even before the statement was made. And because of that, those discussions, eventually it was established that at 36 physical locations served by 29 teams.
So should I understand the ECN case to be, there are these people who are in the queue, and they have information that there are other people outside the queue who want to vote, who are not being accommodated. Is that the case?
No. The ECN's case is clear. In respect of all the polling stations, but for
I'm talking about the 36.
But for the 36,
Yes.
everybody who was in the queue was either attended to before 9 o'clock, that is where those polling stations closed and started counting and so on, or after 9 o'clock, or through the course of that night. Everyone.
But why not just end with those in the queue? How did they define this other group of voters? That's what I want to understand. That the people were denied the right to vote. The ones who were in the queue, you cannot say they were denied the right to vote because they're going to vote.
Yes.
How did they define this other cohort?
There were those places that were not reached, the mobile polling stations that were not reached, because the teams were held up at other places. So if you did not get to the mobile polling station, obviously those people could not vote. Perhaps your Lordship can regard page 206. Page 206 of the record, yes, affidavit of the Commission. It says, by 10 o'clock on 28 November, the Commission had reliable information indicating that in respect of the 36 police stations which are referred to below, some of the voters were in a queue at 2100 hours on 27 November 2024, could not cast their vote because the ballot papers had run out and could not be replenished in time before the voters left the queue. The ballot boxes were too full, and could not accommodate additional ballot papers, causing voters to leave the queue. Furthermore, some mobile stations, which are referred to below, could not be reached by the polling teams on the 27th. And in respect of each of the other polling stations, whatever issues there were resolved, so those ones were allowed to vote.
Before you move on to the next part of your submissions, I'm trying to understand this. Much was said about an extension in relation to the proclamation that was issued by the President to allow people to vote for the 2 days that we've heard. I read somewhere also in ECN's affidavit that, in fact, there was no gap there in terms of the dates within which people were allowed to vote, the polls were allowed to run. Can you take me to that evidence there? Yes. And what your understanding of it is?
Yes, Your Lordship, I will take Your Lordship there. But as I've been explaining now, at some polling stations there were still people in the queue after 9 o'clock on the 27th. Those persons continued to vote past 12 o'clock in the early morning hours of the next day. Now, this actually brings me also to that dichotomy between the polling day and the hours. One where the President has the power to make the decisions, and the other where the Commission has the power, or Commission or the returning officers have the power to make the decisions. There seems to be some conflation, especially by the LPM, on these two different things. Your Lordships, we have gone to the trouble of listing the references in the Act in respect of the polling day and the hours. Perhaps if I can find my yes. So the Act clearly draws a distinction between a polling day and polling hours. Polling hours are referred to in section 993, subsection, is it subsection 1? Yes. Subsection 1 of section 93. And Your Lordships will see there the person who has the authority in regard to polling hours is either the Commission or its officials. And it's 28 hours of 7 o'clock to 2100 hours. But those hours are flexible. They can be changed by the officials, as was submitted by my learned friend for the but it's something different. It is referred to in section 64. First, in section 64, subsection 1. B. It says, if a general election by-election is to take place in accordance with section 63, the President must, by proclamation in the Gazette, make known, subject to subsection 2 and 6, the date determined by the President upon recommendation of the Commission, upon which a poll must be taken. So that polling day does not have hours. So when the President deals with makes that day known, he does not have to deal with hours, because the hours of polls are governed by section 93, which is something else. in Section 93, subsection 1, reposes that power to determine the contingencies in the Commission. So you cannot speak of polling day with respect to the hours when you consider the power of the President. The President only designates the day on the recommendation of the Commission. And like any day, a day has 24 hours. So our submission is that when the proclamation was published at 2300 hours on the 28th of November 2024, it became effective immediately after the close of the 27th, that is at 2400 hours. So that is the import of Section 12, I think Section 12, subsection 2 of the Interpretation Proclamation. That is what it says. Okay. That is what it says. So so the proclamation becomes or comes into effect on the first second of the 24th, or the 28th, sorry, of the 28th of November 2024, on the first second.
That's also what Duplessis says, what I've handed to them.
Yes, okay, that is also what the judgment that was handed to the court, Duplessis judgment also. That is the extract that was handed to the court by my learned friend. Yes, yes. So, but by that time, when the proclamation came into effect, there were still people in the voting. Your Lordship can have regard to page 316 of the record. 316. 316.
316.
Paragraph 194. 194. There we refer to the fact of the voting continuing up to the time when the proclamation became effective. So we say that there was no break as far as the day is concerned. That is now the powers of the President.
You have to speed it up, and I think
Yes.
you have to wrap it up, actually.
Yes, Your Lordships, may I just hand up? I have copied references to polling day, taking of the polls, and the polling hours in the Act, just to show the juxtaposition of these different provisions in the Act and how they apply, so that there is no confusion between the polling day and the polling hours and the taking of the poll, that is the actual voting. I must just find, my copies are somewhere here. May I just hand up those references? It will perhaps be useful for the court to have regard to that, because there is some conflation of these provisions in the Act So they are used differentially. They are not the same thing.
Don't feel sorry for us. All these people we must.
So the submission, Your Lordship, in regard to the hours of voting and the powers of the President must accordingly be rejected. The President certainly could repeat what is stated in Section 93 in brackets 3, in brackets 1 of the Electoral Act, because that is what is the indicative hours of voting. But this can change, as we have seen in terms of Section 94 and in terms of Section 93 in brackets 3 of the Act. So what we are submitting on that score is that, in fact, there was no break because the polling day that was designated by the President ordinarily would end at 2400 hours. And those facts, or the factual amendments on the voting continuing, at the time the proclamation came into effect, that is Proclamation number 34, came into effect, those are not disputed. So I'm hearing the court saying it is affair with the subsidiarity doctrine and that I don't need to belabor it. I'll move on. As far as the proclamation itself is concerned and the reading that is proposed on behalf of Dr. Itula, that the proclamation require that voting should take place throughout the country. Our submission is rather simple. A proper reading of the proclamation indicates that polling stations were previously made known by the Commission, both in the Gazette and in the publication that is attached to the answering affidavit. Those polling stations were known. When the President was requested to extend the voting at specified polling stations, those were identified also. Those were also identified. They appear in the press release that was made by the Commission, and the President was requested to extend the voting at those specific polling stations because of the problems that were encountered at those polling stations. But those polling stations are not any different, except that there are only 36. There are 36 of the polling stations previously identified in October by the Commission. So they are not new polling stations. And what the proclamation seeks to do is to isolate the 36 from the rest. That is what is referred to in the schedule. That is why the proclamation refers to its own schedule. So from those ones that were previously identified, these are the ones where the polling should take place. That is what the proclamation says. It is not a difficult reading, because if that is not what the proclamation says, the court has to consider why refer to a singular schedule which is not even attached to the very proclamation but to the other proclamation that was previously made by the Commission. When the proclamation refers to a schedule, and does not even identify the schedule that is attached to it. That is the reading that is proposed by the applicants. So what we say is the schedule that GG 34 identifies is a schedule that is attached to it, with reference to the polling stations that were previously made known. That is the simple reading of GG 34. It does not talk about extending voting to whole of the country. The facts that were available to the President, the facts that were available to the Commission only indicated that at the specified polling stations, those voters may have been disenfranchised. So, Your Lordship, the Deputy Chief Justice asked a question to my learned friend for the President, but why does the Commission basically assume if people have got the right to go and vote anywhere, why the 36? Why couldn't they go and vote anywhere else? Okay, there are two answers that are provided by the Commission in regard to that question. I will get the page reference now. There are two answers that are provided by the Commission. The first relates to the identification of the 36 polling stations, because it is only they, those 36, where the problems were such that voters may have been disenfranchised. Only the 36. Those facts are not denied. But Your Lordships will also recall that elections the Commission says if it had to distribute or redistribute the ballots, ballot books, now the unused ballot books, from where they were found to where they were needed throughout the country, it would defeat the very purpose of the extension. Because in that event, all the polling stations would then have to account within the short period of time for all the unused ballot books. They had to account for them. And those ballot books then would have to be taken from where they were and to be distributed to wherever they may be needed. But imagine, at that stage, when the decision is made to allow voting to continue at the 36 polling stations only, the Commission does not know at that stage, at the 36 polling stations, how many voters did not have an opportunity to vote because of various reasons that I have made submissions on. The Commission knows, as a matter of fact, that at all the other polling stations, whatever problems there were resolved. All the voters that were there were allowed to vote. Now, how does it decide to redistribute these books to all the polling stations? And in what time to allow for voting to be completed within the window, what my learned friend referred to as the menu, the 5 days between the 40th and the 45th day from the nomination day. This would present great logistical difficulties to the Commission. it would be impossible to achieve that objective, but most importantly, it was not necessary. It was not necessary because those persons who wanted to vote attended at those polling stations. We deal with it at page 289, page 289, 89 of the answering affidavit. Paragraphs 107, 108, 109, 110 on page 290. Of the affidavit. We submit that that was a reasonable.
If I was on that day in Epupa, but I live in Windhoek, and I was denied that opportunity, I must now go back to Epupa from Windhoek. I just want to understand that logic. I will have to go back to Epupa to go and vote there.
Yes, Your Lordship. The assumption was that the persons would vote at the places they attended to. But let's look at the contrary. There is not a single affidavit from any person, be it from the LPM or from the IPC, that's at Epupa. There is no evidence whatsoever suggesting that there are people that wanted to vote that otherwise were unable to vote due to the problems encountered at the 36 polling stations. There is none.
But you have by far exceeded your time limit. So
yes, my Lord, can I just conclude with the submissions on cost?
Yes.
If Your Lord, with regard to the case that was brought by the IPC, there was a reliance placed on a version proffered by Ms. Occurrence. As it turned out, that version was untruthful. I hear the court say, but why is the commission even here? If a party puts up a version that is untruthful, I was personally present at the inspections. I personally conducted the inspections, that's what she says. And that version is completely untruthful. She was not there. And it's demonstrated by the returns or the attendance sheets that were kept of persons who attended at the inspections. And then reliance is placed both, not only in the court below, but also here, on that version that is known to be untruthful. Your Lordship, we submit that that conduct is frivolous and it should be visited with a cost order. BioWatch cannot save the IPC. Also, as far as the LPM is concerned, there are a number of allegations relating to malafidus of the president. No, Your Lordship, I'm not. I am submitting why costs should be awarded.
Yes, but costs for for the entity you represent, which is
Yes,
an
Your Lordship.
impartial party.
Yes.
It's one thing for the president to ask for those costs, but it's not really something that affects the ECN.
But Your Lordship, my submission is if the party misbehaves before this court by making wild allegations, yes, wild allegations about bad faith. Of course, the president is alleged. The president acted on the recommendation of the commission. That is a fact. So those allegations are made regarding the Attorney General, that he's a member of Swapo.
Put a different light on it, Mr. Narib. In layman's terms, the message that the court sends by way of a court order is to say, look, this case did not deserve to come to the court. That's essentially the message that you send, in layman's terms. Now, Mr. Heathcote quite eloquently set out the background to this thing about what is there in the public minds and whatever. Imagine if there was no court challenge. That's the perception the public lives with. Is it not better that a thing like this is litigated and the courts deliberate on it and give a judgment and it's clear in the public's mind? Either there was something wrong or there was nothing wrong. So I'm trying to put a different light in the bio-watch context, that there could very well be a case where this sort of, and remember what it is, the focus has come to turn down on now. It's whether or not the president's exercise of the extension power was lawful. And this court makes an authoritative statement to suggest such a thing should not have come to court. I'm afraid you are losing me, at least me, in the process.
No, I'm not suggesting that, Your Lordship. I'm suggesting that gratuitous statements don't belong in that in the application. Yes.
But the chilling effect, I think what is being referred to by the Deputy Chief Justice is the chilling effect that such a court order would send to people who may genuinely, maybe wrongly, rightly or wrongly, believe that there was something wrong, and they're trying to test whether their belief that there was something untoward in the conduct of elections must be tested in court.
All that I'm asking the court to do is to deprecate the unmeritorious assertions that are contained in the affidavit. I am not for one moment suggesting that the question whether the president had the power to extend is not a serious one, or is not the one
caution. The Republican Party case in 2005, in April, Justice Damaset, you were part of the bench. The court, one of the findings of court was that our law on election challenge has been developed carefully to achieve two main purposes. The first one, obviously, is to, through the judicial adjudication, to ensure that our electoral system does work, accountability is maintained, fairness is maintained, the fact that the election is free and fair is maintained. That's one. Why our law on election challenge have been carefully developed over the years. But there is another chief aim and purpose, which is to maintain the court's ability to resist against calls to invalidate elections on baseless allegations. Those two. Those sentiments with respect are in the RP versus ECN judgment. With that in mind, every time the court applies the law on the test, whether it is 115 test or whether Rule 7.1 of the rules of this court, which says that if you come to this court, your application must be supported by affidavit, which must have facts or on which the relief sought is based, but it says, in addition, that that affidavit must also disclose specifically and clearly the nature of grievance, and the reason, therefore, Chief Justice, that is specifically there because precision is required in matters of this kind so that you know that the complainant or the applicant, the relief he or she wants is the one of recounting the announced outcome of the elections, or is it to set aside the whole election process, starting with submission of names of candidates, etc., or what exactly is the relief being sought, Your Lordship? Hence, precision in matters of this kind is very important, not only on the issue of course of action, the claim, but also on the remedy sought by the applicant. Hence, Your Lordship, one must guard against losers performing electoral rituals every year after 5 years. Every after 5 years, there is a ritual in a form of a useless application. When I say useless, without factual and legal basis coming to court. The rules of engagement are designed to keep out cases that do not deserve to come before this court. Let me then address the constitutional context, Your Lordship.
I want to point out the word useless that you used there. It's not for a party to determine.
I apologize.
And it's not a language that we encourage in this court.
As a court, yes. I realized that and immediately went back and said it's a case that has no factual and legal basis, but I do apologize, Chief Justice. I address now the constitutional context, and this, Your Lordship, is very, very important to the ultimate determination whether or not the President, when he acted in terms of Section 64, subsection 1B, had power or not. The first one is that under Chapter 3, 17.2, Article 17.2, gives every citizen who has reached the age of 18 the right to vote. Your Lordship, you have seen that we refer to the judgment of August versus ECN in South Africa, where the right, the fundamentals and the content of right to vote, particularly in a country like Namibia, where a certain population was denied the right to vote in the past, is so important. That is important. The right is given that if you are 18 years old, you have that right. Then the next section is that article is 94 subarticle B, Your Lordship. The state did not just look at Article 17 and stand idle. It created a mechanism, a structural, legislative and executive mechanism for people to be able to exercise their right. That is to then establish an electoral commission which has, in terms of the Constitution, a number of functions. I name few of them. It's supervise, control, management, direct, etc. The president doesn't have that direct power. Of course, is a stakeholder in terms of certain power, but the underlying and the primary decision maker, manager, supervisor, controller on the ground is the ECN. And that our lawmakers have done well, placed it in the Constitution. Then we have ECN. The second one, which is important, is Article 5 of the Namibian Constitution. That article is important. One of counsels who argued before me said that article obligates the executive to protect rights. Not only the executive, it says the legislature, executive, the judiciary, and where necessary or possible, also private institutions and individuals must all protect and uphold fundamental rights that include, of course, Article 17.2. And I'm saying this because when I will make out the case as to why the president acted lawfully, this must be at the back with respect of our mind that there is a right, then there are stakeholders involved that include a secondary stakeholder, the president, primary decision maker, the ECN, but there is constitutional obligation
Want to find out from the transcriber? Are we okay? Very well. Okay. Very well.
I'm trying to shout because yes, may I proceed, Your Lordship? So what I was saying, Your Lordship, Article 5 is not a dead letter. It's a live and obligatory provision so that when this court adjudges this matter, looking at the issue, it also has the right in adjudicating, obviously, depending on how the issues are pleaded, to uphold and protect such rights.
A few seconds again, Mr. Namanja. I'm so sorry to interrupt. But you know, when it rains, we do have difficulties with the transcribers. It's affecting. What do we do? No, we'll carry on nevertheless. We'll carry on. Do proceed, please, as long as we can hear each other.
As the court pleases. What I was saying, Your Lordship, we must take it and accept it on the common cause facts that I will be referring to. One must assume, unless there were a suggestion that, remember, this is not some kind of a review against an executive decision of the president. Unless there was some allegation that the president did not apply his mind and so forth, on that basis, there was no attack on that basis. One must take it that the president was aware of the existence of Article 5, and as far as the facts placed before him concerning residents or voters in the 36 polling station. I then moved to the statutory context, having dealt with the constitutional context. The first one, Your Lordship, and this is very important, when LDP versus ECN was decided on the basis of the 1992 Electoral Act, it did not have a special provision like Section 1, subsection 2 of the Act, 2014 Act. That is a progressive introduction brought about by Parliament, Your Lordship. You will see that that section in mandatory terms asks and enjoins anyone, and this includes, of course, executive and ECN, the president, and on the other part, when interpreting also the court, it says in the application of the Act and interpretation of the Act, regard must be given to the fundamental Bill of Voters' Rights in Schedule 2. Schedule 2 is there, and I do not, in the interest of time, Your Lordship, one of the content of Schedule 2 is to embrace, promote, and maintain franchise. In other words, create an opportunity that, as far as possible, make it easy for people to vote. Don't act in a manner that disenfranchise anyone, Your Lordship. I will, of course, address the issue of why was it necessary for the president only to apply the extension to the 36 polling station on the fact. That, Your Lordship, is in addition, when the court applied the law then, in 2013, this provision didn't exist. And of course, somebody may say, but it's just reinstating what ought to have been the case. But of course, it has been given an statutory emphasis that is obligatory on the president the day he was considering whether or not he must act on the recommendation of the commission. He, of course, have to, in application of his power under Section 64, act in a manner that conform to the obligations under that section. Then the next one, Your Lordship, is then Section 64. And I invite the court, with respect, to go to that section because much has not been addressed by the applicant's counsel about the scheme and structure of the section, Your Lordship. With respect, before I go to that section, Your Lordship, I was thinking when the court was posing questions to my colleague to find a relevant case that is important to statutory context. And I found a case, Your Lordship, for your notes. It's not in our heads of argument. It's a case called Minister of Water and Sanitation versus Sem Corp. Caesar, not Caesar, but SIZA. Water Pty Limited, 2023, Volume 1, SA, Page 1, South African Constitutional Court, Paragraph 88 to 89. And may I read out this important paragraph before we deal with Section 64, subsection 1B. It says, 88, starting with 88, Your Lordships, in our law, it is common to have administrative action comprising two decisions taken sequentially by different functionaries like ECN and President, Your Lordship. If this kind of administrative action occurs, each decision is subject to scrutiny to determine its validity. If the first decision was properly taken, it cannot be vitiated by irregularities which occurred when the second decision was taken. Then section, paragraphs 8, 9, Your Lordship, in the interest of time, Your Lordship, Your Lordship will read. Now, if one goes to section 64, remember, Your Lordship, when I took the court to the constitutional and statutory context, I deliberately used the terms like the ECN is a primary manager, primary controller, primary supervisor of the election, and the president has some executive powers as a stakeholder, but of course, I'm not saying his decisions are not decisions. They are executive decisions, but to complete the process, Your Lordship. Section 64 says, if a general election or by-election is to take place in accordance with Section 63, the president must, and I highlight the word must, by proclamation in the Gazette, make known, in other words, announce, B, subject to subsection 2 and 6, the day determined by the president. He doesn't primarily determine. It is upon recommendation by the commission, upon which a poll must take place in the election. And Your Lordship, you will then see that 64 subsection 3B is that that day must be, Your Lordship, not less than 40 days and not more than 45 days on the count, Your Lordship. The submission of names of presidential candidates were on the 16th and 17th of October. We know now 27th to 30th fall within that period, Your Lordship. Now, there are jurisdictional facts for the president to act in this section. Jurisdictional facts. One of them is not a mere objective fact that must be there. It's an objective because there must be a recommendation by ECN. But this is kind of a jurisdictional fact that come in the form of a decision deliberated upon and decided upon by ECN. The fact speaks about it, Your Lordship, as the chairperson of the ECN spoke, how they consulted, how they had a meeting and decided, as the commission, Your Lordship, they decided to make specific recommendation to the president. So, and then the president, obviously, then there comes recommendation pertaining to 36 polling station. The next issue is, of course, 64 subsection 3 requires that those days for determination must be not less than 40 and not less than 45, not more than 45, Your Lordship. And remember that in 63 there is another requirement, Your Lordship, not more than 3 months and so forth. Nothing of those is an issue in this matter, Your Lordship. As we understand the case for the applicant is apparently the applicant, it was open for the applicant to attack the apex decision of the president on this basis simply to say the president doesn't have power. That is essentially, Your Lordship, when you look at the judgment of the Electoral Court, when we argued whether the issues that arose in the Electoral Court are the same, we were made to understand by the applicants that the issue in this court will be a various issue in relation to the power of the president, Your Lordship. That complicates their matter with greatest respect, as I demonstrate. First of all, the president, Your Lordship, it's a fact there was a decision properly taken and not. And that decision, Your Lordship, I would submit that that decision is in accordance with Section 4. Section 4, Your Lordship. Section 4, subsection 20, rather. 20. Yes. It says, Your Lordship, without derogating from the generality of subsection 1, obviously 1 is the general one that they have independent power to manage, control, and so forth. Say the commission has further powers and functions 2 and O, exercise and...
Section 4, the Electoral Act.
Yes, Your Lord.
420.
Yes, Your Lord. Am I...
Oh, yeah, I see. So you are reading first 2.
Subsection 2.
Okay?
Is the court with me now?
Yes.
Yes. I'm reading, Your Lordship.
Very well.
May I proceed?
Do proceed, please.
Exercise and perform any other powers after the primary powers in subsection 1, Your Lordship, and functions conferred and imposed upon it by and under this act or any other law which are necessary or expedient for purposes of achieving the object of this act or any other law. Now, the power to recommend a date is found in section 6, 4, subsection. One of the powers of the commission is to place a recommendation before the president in relation to a poll day. The only limitation is that it must not be less than 40 days and not more than 45 days. So that power, when it says exercise and perform any other power and function conferred and imposed upon it by or under this act, that could conceivably and perfectly and appropriately be one of the powers, because, Your Lordship, unless their decision, their substantive decision to recommend is attacked on the basis, Your Lordship, assuming there was a review and say, look, your decision was irrational or you don't have a lawful power to make a recommendation in the circumstances. If Your Lordship accept that once the ECN as a primary manager, controller and supervisor bring certain facts to the president which are not disputed like in this matter, and those facts appear to favor furtherance of the right rather than restricting a right, then Your Lordship, facilitating an opportunity to vote is in accordance with the Act, is in accordance with the Constitution, and most importantly, is in accordance with the Bill of Rights of Voters under Schedule 2, Your Lordship. So now, therefore, if you accept with greatest respect that the Electoral Commission acting bona fide and without a bad reason in law or in fact, then the president was under obligation to act, Your Lordship. For his action will be to promote and achieve the objects of the Act and the Constitution's actuary, which is to open up and facilitate that people vote, Your Lordship. Now, Justice Damas, Deputy Chief Justice, in one of the matters that I argued recently, you in a nice way, I'm not saying, you warned me that it is dangerous for a court to find itself deciding a litany of issues. You referred to a particular principle, but for now I forgot the principle that you can end up just deciding issues which are not the issue identified in pleadings. Focus on what is pleaded. Now, as I understand the case, Your Lordship, of the applicant, if you go to the facts, at page 15 of our heads of argument to page 25, we listed what was before the president and not contradicted by Dr. Itula, as well as Mr. Swapo. That includes, Your Lordship, and I go one by one. If the court go to page 282 of the record, Your Lordship.
Are you saying that if the applicants had proved that the extension was done with the purpose of favoring Swapo in those areas, his decision would have been wrong under those circumstances?
I'm saying the facts put up by the president and the ECN at the election and choice of the applicant is not disputed. Once you accept those facts on the Plascon-Evans test, those facts, Your Lordship, unless there was an attack on the basis of lack of rationality or on the basis that the President acted unreasonably, those facts form a justifiable factual material for the decision of the President. But I will come to the issue of Swapo, Your Lordship, being favored. There is no facts proving such serious allegations, Your Lordship. May I go to the record where I wanted to?
Yes, please.
Page 282, Your Lordship, paragraph 91 to start with. First of all, 89 to 91, the issue of these seriously maligned machines is addressed, the tablets, so-called tablets. But in 91, the chairperson of the ECN put up a version in relation to what has happened and why it was only necessary to put up, to extend in respect of 36 polling stations. That version under paragraph 91, Your Lordship, for your note, is responded to by Dr. Itula at page 562 562. No, rather, with greatest respect, it's have to sweat around to look at this affidavit because there is nothing. In fact, it was not addressed. Remember, Your Lordship, the way Dr. Itula chose to answer is to simply write an essay and doesn't specifically engage this particular allegation. There is no reference to that paragraph or any other paragraph, Your Lordship. His affidavit is at page 564 to 580. Your Lordship, and this is serious. Both the President and the ECN chairperson, and in addition Swapo, engaged ever allegations. Not a single one has been dealt with head-on by Dr. Itula, including these allegations. So, Your Lordship, in the absence of an attack by way of a review on the rationality of the President to only extend in respect of those polling stations, on the basis of the version that the problem that existed at other pollings, 247 polling stations, remember, Your Lordship, that there were over 4,000 polling stations. Let me make this clear so that also the public also knows. There were over 4,000, and it's on in the affidavit, 4,000. Exactly. Yeah. Where there were alarms raised on the possibility of ballot papers running out, there are 247. And ECN says, we managed to fix that problem, and everybody at those 247 polling stations who was in a queue by 9 o'clock was able to vote, Your Lordship. So we in fact, they used the word restock. We restocked all those polling stations. And the fact says, unfortunately, it's all over. The 36 polling stations, the problem remained. 36. On that basis, Your Lordship, when you apply Plascon-Evans, you can take it. And once you have that version, it's not attacked that it's irrational or on the basis of equality, discrimination or whatever. So one must accept it. If the President has power, based on the facts given to him, he could act in that way, because there is another fact that is not disputed, and it's this, Your Lordship. The ECN says Remember under section 105 and 107, if your station is done, your polling station is done out of the 4,000 on that evening, there were no people in the queue by 21, and 21 comes, you are under obligation to start counting. And that version is there. Some polling stations started because there were no people in the queue. Those who finished also in accordance with the law started voting. Counting, sorry, your Lordship. Started counting. I don't want to go in a debate whether it was justifiable, rational for the president, but the good reason is on the paper, in the fact that, assuming the president then said the whole country, in other words, ignoring the version of the ECN that other polling stations were sorted out, and everybody who had to vote, voted. If the president ignored this version, then, and on the 28th, extend for the 29th and the 30th, then the outcome would have been even those stations that have in the meantime started counting, posting, and doing those packets for purposes of retaining officers to do the return in terms of section 108 subsection 2. You would have then have them voting on top of announced results at those polling stations. So, but we don't need to go there, Your Lordship, because the president is not attacked on the basis of rationality or unreasonableness and so forth, or lack of application of mind. The president is attacked apparently. He does not have power to extend, Your Lordship. Now, to then move and Your Lordship, to also give the court another page, LPM made, with respect, LPM responded, ECN in relation to LPM made the allegations at page 792 of the record, 792. Yeah, particularly paragraph 153 onwards to 7, it starts there from paragraph 153. The answer by LPM, frail one, is at page 984. There is nothing at page 984, Your Lordship. In other words, to discard the facts and the explanation why it was done that way, Your Lordship. Now, I want to make submissions then to demonstrate, given those facts, given the constitutional context, given the statutory context, Your Lordship, the president can easily, without offending legality, act, say the following. One must be careful. The power to extend are executive. The power to determine a date, Parliament allocated it to the president. But the president doesn't just act. He has given certain jurisdictional effect that must exist and a recommendation and so forth. And there are some restrictions and period-wise and so forth. Now, when this court, with respect, goes and consider this matter, may I give certain example to demonstrate to court that one must not make executive decisions a difficult undertaking for no good reasons. I say this. Remember, the same power can be used in respect of a by-election, Your Lordship. By-election, the section says that. For instance, if in Impalira Island, I know it's in Kabe West, in Zambezi, assuming the councillor, there is a by-election because the regional councillor for Kabe West resigns, The facts on the ground is that for you to go there, canoe or vessel or whatever.
Or helicopter.
Exactly. To go to Imparira Island, where there would be voters. The president, in accordance with the proclamation, has made a date on recommendation. Unbeknown to the president, of course, not having supernatural powers, that day, other villages, not on the Imparira Islands, they vote effortlessly without any problems and so forth. Then there is problem with flood and so forth on that village. It is on that island. The president is given, same situation, is given facts by the ECN. The presiding officer, who is there, would have in any way have the power in terms of 94 subsection 5 to say, to stop everything, it's raining, we can start on another day. He would have been able to do that. But because, of course, of the importance of the matter and that there must be a public holiday so that people, the employers, do not give problems to the employees, the ECN, after getting a report from the presiding officer, decide whether to approach the president to say, make it may be raining, make it the next day, and so forth. Your Lordship, the law is not about nice principles and so forth. That's why, Your Lordship, you can see people moving around. It's for the court to be not divorced from the reality outside of this court. Why we can see people moving around when one makes decision is because these are things that can happen, Your Lordship, every day. How on earth, with greatest respect, can my colleagues argue that in those circumstances, on those principles, the president does not offend the requirement of the recommendation, does not offend the 45 days requirement. The president is opening a door for a number of voters. And as it turned out, 9,000 Namibia at those polling stations were able to vote, Your Lordship. So the example, with greatest respect, given by Justice Damas, Deputy Chief Justice of the Governor, I don't want to argue a matter which is not the one pleaded before court, but I have the following to say. Of course, a governor cannot act because in the first place, there must have been a recommendation from ECN. In the first place, the example given, Your Lordship, is it would have been somebody acting in a position where he's not in a better position than somebody in the street coming up with a piece of paper and saying, I declare the election to be on this day. This matter is simply on the facts of this matter, which is there is a recommendation. There is a huge problem. The other part of the problem is fixed. And these people must be given an opportunity to vote. Who is complaining about that? And why? Remember, Your Lordship, assuming there were 2 days for the election and the president amended and took 1 day off, like in the circumstances just before you plan your things that I will go to South Africa to come back from Cape Town, knowing that there are 2 days. All of a sudden, the president takes off 1 day and leaving you out. Of course, in those circumstances, the applicant would be able to demonstrate that there was a disenfranchisement of the voters, Your Lordship. Not in this matter. I therefore submit strongly, so Your Lordship, our heads of arguments are there. We have referred to case law, demonstrating how it's not easy to deny the president who is using executive power in a serious situation to address it in a manner of a Minister of Works and Transport deciding whether or not trucks must go through this road or that road. It's a serious fundamental matter to the right that a section of this country had long been denied that right. With that history in mind, we will always do everything to open up and allow everybody to vote. I conclude, Your Lordship, with these small submissions on the LPM notice of motion, Your Lordship.
Yes.
With greatest respect, I think with respect, there must be discipline in pleading our cases. The notice of motion with respect is convoluted. We as, first of all, I have decided to leave out whether they must join or not. But there is a problem, Your Lordship, because LPM did not commit itself to whether it find the court grants it the right to be an applicant. It must cease to be a respondent. It actually say in the papers that we will both be the applicant and respondent. It's there in the affidavit, Your Lordship. Now, this gives us a problem on the facts as far as adjudging facts against us, Your Lordship, on Prascon Evans, whether they must benefit as applicants or respondents, Your Lordship. But that is not the bigger problem. The bigger problem is this. They are also attacking the decisions of the ECN. If Your Lordship go to page 588,
Right.
588. Yeah. Your Lordship, in the interest of time, my colleague, Advocate Heathcote, has already dealt with other relief. I'm more interested, Your Lordship, at page 589. Your Lordship, if you look at the Act, section 1684, 168E, sorry, 1 of the Act,
Okay.
dealing with the powers and functions of the Electoral Court, Your Lordship. Yes. That section says that court has a power, amongst others, to review any decision or processes of the ECN. Not president, but ECN, Your Lordship. So in other words, it doesn't even say in relation to the National Assembly, it says on any electoral issue. That's what the section is saying. Furthermore, in the rules of the Electoral Code crafted by Judge President, Rule 13, I think it's 13.4, gives a time period within which a review of any particular decision of being reviewed should be brought, which is 14 days from the time you came to know of the decision. Now, the first complaint and grievance on our part is that, Your Lordship, you look at the judgment of the High Court when we were told we must stay. We were told on this issue, when we come to this court, there is but one issue raised by the application in relation to the proclamation. That's what we were told. Now, if you look at 5.1, that resolution, whether it is being attacked on the basis of legality or other underlying reasons in the administrative law realm, it doesn't really matter. It's actually something that qualifies as a decision to be reviewed on any electoral issues by the Electoral Court. And it has nothing, if you look at that, while it may be in a journey to attack the proclamation, it's not attacking the proclamation necessarily, Your Lordship. Then, again, 5.2 and 5.3. Your Lordship, then, you also then look at the heads of argument, both of IPC and LPM, with the greatest respect, they conflate what they are attacking with implementation, because particularly IPC heads of arguments, and we quoted in our heads of arguments where they say, the proclamation was very clear. It applied to the whole of the country, but the conduct of the ECN denied people of other polling stations the right to vote because they misapplied it. Your Lordship, that is exactly, and we quoted portions of the heads of argument. But that act is post-publication of the proclamation. If the ECN, assuming it's true what they are saying, that the proclamation factually and legally applied to the whole country, that conduct is a specific conduct that could be attacked, prone to attack in any review proceeding and say, you misconstrued the proclamation on this basis. The exclusion of voters was a disenfranchisement of voters. On that basis, we want the election, and I'm saying it very careful, knowing that you can't just take a legal hammer and hammer down everything, including nomination. So that is an interpretation. There is a conflation and a confusion, a bigger one, Your Lordship, as far as the submissions of these parties are concerned. Let me just look at my notes, I know. I'm not too sure how far I am with them.
Take your time to look at your notes, sir. Thank you.
There is no time.
Yes, another issue, Your Lordship, I'm just finding, Your Lordship, you may be aware, if need be, I can provide a judgment. There is a judgment of, in Botswana, of the Court of Appeal, is called Law Society of Botswana. There's the President of Botswana and others. It's reported as 2018, Volume 1, Botswana Law Report, 478. Your Lordship, that issue, if one of the justices have come to read this judgment, pertain to Section 96, sub-article 2 of the Botswana Constitution pertaining to Judicial Service Commission recommending a name of a judge to the President, and the President Masisi refused the recommendation. And there is a good debate which may be useful, Your Lordship. I'm not saying this court is bound, which may be useful in interrogating my submissions in respect of the fact that, look, there are actually two decisions that need to be made in Section 64, subsection 1b. First, the manager of the election goes on the ground and identify a problem, make a recommendation required in law, and the President, the law says he must then determine the date. The President doesn't generate a date at all. The determination referred to therein is upon recommendation of the Commission. So in other words, it may even, Your Lordship, be argued, and I don't want to go in that debate. I'm simply saying that judgment may be useful, in fact, to the effect that it's doubtful if the President could refuse those recommendations. Because for what reason? If the ECN comes to him and say, look, we have a situation to go to a village in Opuo yesterday. Our vehicles have to cross a bridge. And because of flood, that bridge fell and we could not take ballot papers. We need to extend in respect of those people in that area. The President, if once the recommendation comes to him in good faith for purposes of the Act, cannot and should not refuse, Your Lordship. The rest, Your Lordship, in our heads of arguments, and none of the argument we make in our heads of arguments, Your Lordship, we are not abandoning them, Your Lordship. In the interest of time,
your head,
Yes, Your
the
Lordship.
arguments in your head. I just want to get the page number of the Botswana case there. I didn't get it.
It's Your Lordship, it's
78.
and 478, and I will ask my junior to produce to circulate the judgment to court tomorrow morning, Your Lordship.
Very well, thank you.
My colleagues are just referring me that it may even be considered, for analogy, Shanika versus Minister of Justice versus the Magistrate Commission. Justice Mainga authored that judgment, Your Lordship. But in regard to Swapo, Your Lordship, with greatest respect, we must not become a country which grow as a democratic country whose citizens have come to believe and to be taught that democracy and fundamental rights means that you can, as you wish, make disparaging remarks and say anything with no regard to those who make constitutional and statutory powers and those who are about and around you. So in other words, Your Lordship, Justice, Deputy Chief Justice, you remember in the ECN versus LDP 2013 Volume 2 Namibian Law Report, you refer to the case of Gates versus Gates. I think it's a 1930-something case which says that the more you make serious allegations with serious consequences to people or the community, you must have stronger evidence, Your Lordship. The same is stated in the matter of Zuma, Director of Public Prosecution versus Zuma, 2009, Your Lordship, Volume 2, South African Law Report, page 477. So, in other words, on what basis, when you tell the nation as a leader of an opposition party and accuse the ECN and the president that without any facts, put up, Your Lordship, and say, look, it's being done to favor Swapo. Even if it is correct, Your Lordship, I didn't find any evidence in the papers. Even if it is correct in the past, Swapo performed very well. But you were given an opportunity to campaign by ECN. Why on earth do you make allegations of mala fide for purposes of favoring somebody in a dishonest manner publicly in court proceedings, Your Lordship? We had to deal with these allegations, Your Lordship. This also go as far as the affidavit by Mr. Itula. And we will ask that they must...
You say Dr. Itula?
Dr. Itula,
yes.
Your Lordship. Dr. Itula aggravated the issue of the National General Secretary of his party. Remember, Your Lordship, we produced affidavit by Mr. Nekongo of the Swapo party and say, no, I was one of the people. She did not, as she says, she was not part of the inspection. If you look, Your Lordship, and I invite Your Lordship to look at it, the confirmatory affidavit of the General Secretary actually says, I attended the inspection at the offices of ECN. Positive averment, direct averment. That is, Your Lordship, at page 63. 63. Paragraph 3, she says, pursuant to the order of the Electoral Court, dated 13 November 2024, I attended the inspection of the material at the head office of ECN and then compiled the report. Look at the answer of Dr. Itula in the reply, Your Lordship, without a confirmatory affidavit. We quoted it in our heads of argument in the last page to say that Dr. Itula actually aggravated this conduct, conduct that should not be in litigation. At paragraph 65, we quoted what Dr. Itula says, and he says, although Ms. Akamus was not physically present, remember she said in the report and other affidavit that she attended the inspection at ECN, then Dr. Itula, with respect, says that for the first time, somebody is saying, although she was not physically present during the inspection, there can be no doubt that she was present virtually. Your Lordship, this is not a game. An election can be set aside. What if we did not come to court? Remember, Your Lordship, even in the context of 115, Your Lordship, you are under obligation with respect to decide an electoral matter, even without respondents. So in other words, the prohibition in 115 still apply. And look at the papers, Your Lordship. We therefore, Your Lordship, seek cost against the two applicants and ask that the application is so bad, in fact worse than other applications that served before this court, Your Lordship, and those are our submissions. Thank you, Your Lordship.
Thank you, Mr. Namanja. Can we proceed? Mr. Kurtz, after that short detour, we are back to you.
Excuse me?
Yes. I'm saying after that short detour, we just made a short detour, now we are back to you. Yes.
Cool. Your Lordship, I want to Your Lordship, I want to make three propositions in reply, two main ones and one small one. I've listened very hard to our colleagues and I've concentrated carefully. The first is an answer to Mr. Justice Damaseb's question about Swapo, the Swapo allegation. And we don't take any issue, as does the LPM, with whether or not the extended voting was to accommodate Swapo. We're neutral on that. We don't say it, the evidence doesn't go either way, from our perspective. So we do not say that the President and the Commission extended the voting to certain stations in order to accommodate Swapo. At the same time, we don't say, and we can't say, that they didn't do that. We're neutral. There was another question, and I think that Justice Damaseb, you had asked me to respond in reply. There was another question that I also was invited to respond in reply. I think it had to do with the counting on the various days, but I can't remember exactly how the question. Sorry.
Okay. Well, I'm told that you have to raise your voice a bit because I think, maybe the microphone is far from you. I don't know.
I think that's the most unusual request I've ever had, because I'm usually told to lower my voice. But anyway.
It doesn't come from me. Yeah? That's a disclaimer.
Let me turn to why I'm going to submit that what I've been listening to for the last 5 hours, 4 hours, and never 5 hours, causes the defense to the application to implode. There's a difference. Explosion, boom. Implosion, boom. Their defense collapses on their own argument. And I want to turn to two aspects to generate that argument. The first is this. It seems, and I say it seems, that it's accepted by at least the President and the Commission that were any of the 36 polling stations set out as a sort of schedule to Proclamation 34, not in Government Notice 305, they should lose. But they both made the affirmative submission, the President and the Commission, that all 36 were contained in the original Government Notice. The Court will recall that. Now those 36, the Court will find on pages 41 and 42. And they are divided into 4 regions. The original large number of polling stations start on page 5, and they are part of 3 schedules. The first schedule is the regular polling stations. The second schedule are actually quite interesting. Are those polling stations, this is on page 36, which are outside Namibia? That's Schedule 2. And then Schedule 3, on page 38, are polling stations for persons who are members of the police force, defence force, and correctional service and persons on board sea vessels. Now, I have to take somebody's word. I've done a check myself to a certain extent. I haven't done a complete check. But Mr. Perumal-Sami, my second junior, tells me that of the 36 polling stations that are set out on pages 41 and 42, 25 do not appear in the schedules to the provisional government notice. Only 11 do. I've checked a few, and I've heard from my learned colleagues, and they're both looking at me with deep frowns on their face.
Yes, because it was never an issue, my lord, and now it's in the reply becomes a factual issue.
Well, it was an issue. It was an issue. 48, Dr. Tulu says the following. On 28 November 2024, the President, by the schedule to Proclamation number 34, established and published fresh, new polling stations. He had no power to do so. My Lord, I am arguing my point, and I think I'm entitled to do so. I'll blunt it out.
Would you like to take a seat, please, for a moment? Just sit down.
It was told to this court it was never an issue. It's in the founding papers. I've searched high and low in the answering affidavit as to whether an answer is it, and I don't find it. This morning, I said, I can't find all the 36 in the schedule to the government notice. Both the President and the Commission stood up affirmatively and said they are there. We checked carefully. 25 are simply not there.
But why didn't you take this point squarely in the papers and listing them so that they could have the opportunity to respond to why they were not
Sorry,
there?
on page 19 of the
No,
founding
I've
papers.
seen what you've said there.
Yes.
But they don't specify which ones are not on the list. Surely you have to do that.
Well, as it pleases the court. But I'm making the point, this is an objective inquiry. Our complaint is that Proclamation 34 is bad in law. We have a range of challenges to it. The hours. We haven't heard an argument about the hours. We've explained it in detail. It's an objective inquiry. Are the 25 or the 36 part of those original schedules, or they're not? The court will decide.
Please correct me. Is that not said in the context of the applicant saying Proclamation 34 created a fresh elections?
No. It's an extension. With respect. You'll see. It's all together, it's all set out in detail in the context of that whole challenge to Proclamation 34. But I'll leave it at that. The court will decide what to make of it. The court has heard an affirmative, let's call it assertion, that the 36 are part of the original government notice schedule. That's their assertion. We can offer, if the court wishes, a schedule to say which 11 are part of it and which 25 are not part. And give it tonight and welcome our learned friends to correct me if I'm wrong. It's an objective inquiry. Did the President create fresh, in the words of Dr. Itula, fresh new polling stations? And it said he had no power to do so. That's what the Act says, Section 89, 89.4. Right there. Central square into the case. I turn to my third point. And this, Chief Justice, I loop back to my first submission this morning, which is this. And by the way, before I move on, I invite our learned friends to repeat the averment that the 36 are part of the schedule, the original government notice schedule, or to withdraw it. But we are accused of making wild allegations by all three of the respondents who have opposed this application. We don't say that it was a wild allegation. Maybe it was a mistake. We don't know. But they are invited to confirm whether those 36 polling stations are new or are not new. Invitation, it's an open invitation. But a long day, a lot of material. It's an open invitation to both the President and the Commission. I turn to my last point. We started off this morning with a reference to the President's answering affidavit in which he said, and understandably so, it was on page 516, 517. Yes. The disenfranchised on the 27th. And this is where we part company and we move away from what the LPM argues. And I want to borrow, if I may, from the debate that Justice Damasib had with my learned friend for the LPM, together with a comment, if that's what it was, that was passed by Justice Smuts. If the President is correct, and we submit that he is correct, then what happened on the 27th wasn't just a violation of any of the provisions of Part 5. It was also a violation of Section 1, Sub 2 of the Electoral Act. Our learned friends, for the respondents, did not suggest, quite rightly, because then I would have accused them of being in bad faith, and I respect the President and my client respect the President and the Commission for not doing this. For not taking the gap, so-called, and saying, well, what happened on the 27th was good. They haven't done that, quite rightly, because they obviously took the view, as they were entitled to do, that the 27th was bad, it didn't satisfy 1.2, Section 1.2, and therefore they extended. That's what they say, and that's what happened. And let me read one sub 2. A person interpreting, that's the court, and applying this act, that's the Commission, must, it's a duty, do so in a manner that gives effect to the rights, freedoms, and responsibilities contained in the Namibian Constitution, and be take into account the Bill of Fundamental Rights and Duties and any other appropriate law. Now, if it's so, that on the 27th, Section 1.2 was violated, if it's so, and we submit on the President's version it clearly was by the Commission, then the question arises, where does 115 come into the picture? It doesn't. Because this is a violation of a provision of the Electoral Act outside the confines of Part 5 of the Electoral Act. It's the debate that I had this morning, and our learned friends had not dealt with it. The second sentence of paragraph 85 of the Tulu judgment makes it plain. And I've listened to the debate about, for example, it was the Prime Minister who did the extension, etc. It's the same problem. Where there is a violation of the Electoral Act and the Constitution outside the provisions of Part 5, 115 doesn't come into the question. This is a violation of Section 1, Sub 2, read with Article 17, and then we turn to what this court said in paragraph 85, second sentence. It does not, however, necessarily follow that in all other circumstances that a court must set aside, and a court certainly retains the discretion, even in a case such as this. And we would submit that's the end of it. And we don't get involved in the kind of debate that I had with Justice Maenga on the question of, well, are the jurisdictional facts set out in Section 115 present or not? In other words, would it affect or not the election result? It's irrelevant when we are outside 115 as a piece of the court. Before I sit, I'll suggest that were inclined to succeed, an appropriate order would be along the lines that I outlined this morning, subject to the contingencies that has developed. That would be the Electoral Commission versus Swapo case, certainly costs of one instructing legal practitioner and three counsel, including a senior counsel. If they so choose, to ask for the 25 and 11 polling stations that are set out in Section in the 36, the division between the 25 and the 11, which are or are not in the original government notice issued by the Commission, as it is.
Thank you, Mr. Katz. No, thank you.
I don't know what Chief Justice, you would like my junior to provide you with a list. It might be useful for the court and for the commission and for the president.
Yes.
So then tomorrow morning, my junior will have prepared the list of which of the 36 are in the schedule to the government and which aren't. It's an objective inquiry.
Please do that. Please do that. Yeah. Mr. Heathcote, yes.
If your Lordship will allow me, the purpose why I've attached the Government Gazette to the bundle this morning was not for that purpose. It was to demonstrate, and my learned friends here can give you all the figures, and everything is in the Government Gazette. They've now only looked at my one, which I've attached. There are many others in the answering affidavit. Perhaps that's where the confusion comes in. My purpose was to demonstrate that if you refer to that Government Gazette of October, you can never interpret GG34 to be applicable to the entire country because of the schedules 1, 2, and 3, whereas GG34 only refers to the schedule attached. That was the purpose, not to give all the polling stations.
So, may I just suggest, in our bundle of authorities, we've actually attached as item 2 it's not a proclamation, it's a government notice 305, 23 October 2025. It starts on page 4, goes up to page 39. It's there. So it's an objective inquiry, it's nothing subjective.
Mr. Namanje, you had reason. What is it that you wanted to address the court
All
on?
I wanted to say, we are actually being prejudiced now because the issue of the power to establish or the existence or otherwise of polling station, as we understood in the High Court and in the papers, we thought we were not going to argue about it today actually. It's even more dangerous and prejudicial to us to be emphasized in a reply. That's all what I was saying. Because your Lordship, in the Electoral Court, we all agree that it was a various issue in relation to the proclamation. So all I'm saying, but we have responded to that, by the way, in our affidavit. I'm just saying I feel like there's an ambush from my colleagues in a reply. No.
I don't want to stand up again, but I do have the last word. I made the point this morning. How can there be an ambush in reply when I made the point this morning? I made the point clear. I said, we've looked, we can't find all of the 36 in Schedule 1. And I invite our learned friends to tell us whether we're wrong or right. Your court will recall me saying that. I did. So how can it possibly be an ambush? It's not appropriate that Swapo can say that my client's ambushing him. It's just not appropriate. When I made the submission before the case, and I asked that our learned friend withdraw it, there's certainly no ambush in reply.
Mr. Narib,
yes, Your Lordship. In my submissions, I've made a submission relating to the names of the polling stations in the Gazette and in the notice that was published by the Chief Electoral Officer. Now, we are dealing with this aspect on pages 263 to 264, or 265 of the affidavit, of the answering affidavit. These things are not disputed, and Your Lordships, they are not disputed. And Your Lordships will notice, when we were responding to these allegations, not a single polling station was identified as not being in the Gazette. For the first time, there is an offer made of what they say is not in the Gazette, and they will make that list. Once we are provided with that list, we can then show them where those things are in the Gazette, or in respect of those mobile polling stations, the number of which were identified in the Gazette, where they are in the notice that was issued by the Chief Electoral Officer. But that was not the case. They pleaded. But we can deal with it. Once they providing it to us, then we can say, but here it is.
Very well. So they undertook to do that.
We will provide you with the list of the 11 and the 25 tonight, the next hour or two, as soon as we get back to to as soon as we get back to a Wi-Fi laptop place, it's quick. Exercise are done. And the Commission can take as long as they want, the President can take as long as he wants to deal with that list. It's objective. It's either there, and if we're wrong, we're wrong. But we've done a thorough search, and that's the answer. We were surprised when we did the search.
After we break this adjourn to go and write our judgment, we have to deal with this factualism. What if we find inconsistency one or the other? Do we call you back? What do we do?
Well, it's either we write, and we say we win anyway on all the arguments that the courts heard. 5 hours of argument. I've made the point that their case implodes for the reason that I've made about Section 1, 2, and therefore 115 doesn't apply. But I do want to make this point.
This is not how this court functions.
I agree. Justice Damaset, I agree entirely.
I'm worried.
Justice Damaset, you've heard submissions from the President and the Commission that all 36 are in the schedule. It's a very serious allegation. And either the Commission and the President are correct, or they're not. And if they're not, this court should consider what the implications are when the President and the Commission come to this court and they tell the court the 36 are in the schedule when factually they were not. That's all. And it's not something that this court can just sweep away and say, well, we win anyway or we lose anyway. It's a very serious situation that the President and the Commission have told this court, and if they're right, well then we'll have to withdraw the argument. But that's what we've found objectively. We've looked, we've been careful about it. My learned junior has gone through it 3 times. And I've said to him over and over, are you sure? How can you be so sure? Because you've heard the argument from the President and the Commission. And he says they're not there.
He was looking at my annex.
Very well. We heard you, Mr. Katz. Mr. Premier.
May it please the court, Chief Justice. The LPM case is a simple virus case. It does not deal with any irregularity. And the facts in this case and the argument advanced on behalf of President and ECN proves the unlawfulness. And this court, all this court has to deal with is the legal effect of the President's and ECN's conduct. And it's important to deal with the facts, as Justice Damaset has said. And I intend answering the court by going by what this court must accept are the facts. First of all, I invite.
In reply, are you not? In reply, yes. And you are going to take us through the facts again.
No, not all the facts. Just the objective facts. Why Proclamation 34?
Are you not supposed to reply on the law, on the issues of law?
Yes. And that's what I intend doing, my Lord.
Yes.
To show, we intend to show that Proclamation 34 is void from and has no legal and has no legal consequences from the 27th of November at 9 o'clock. That much is clear. And I invite the court to go to Mr. Heathcote's bundle at page 78. It's the bundle of, I think
we've been furnished with quite a few bundles now.
The law, the facts,
it's the legal instruments
bundle.
It starts with the old act.
It starts with the old act, 1992 act. Advocate Premier made the argument based on the jurisprudence of this court that Proclamation 34 is void, is a nullity, and nothing can stand from it. The President made the argument that, and if I take Proclamation 28, is very clear. It says, I have determined Wednesday, 27 November 2024, as the day on which a poll must take place from the hours of 7 o'clock to 2100 hours for the election of the President, as well as for the election of members of the National Assembly. So the President already set the time, 7 o'clock to 9 o'clock on the 27th. If I may take the court to section 93, subsection 3 of the Act. That section in fact, before I do, it's at page 22 of the same bundle, my Lord. Section 93, subsection 2, firstly, says the Commission may alter by notice published in the Gazette at any time before the commencement of the poll, the polling hours referred to in subsection 1A in relation to any polling station in Namibia in respect of any polling day of an election. The power is given to the Commission, not to the President. Secondly, the time to alter that is before the commencement of the poll. Crucially, section 93, subsection 3 says, despite subsection 1, a presiding officer must permit every voter who, at the time of the closing of the poll, is in attendance to vote, to record his or her vote. That power is given to a presiding officer. A presiding officer is defined, is a defined term. It is not here. I invite the court to, no, it's in fact at page 14. It says a presiding officer means a presiding officer appointed under section 65, subsection 1C. This court, in the judgment of Justice Damasep, Namibia Competition Commission, against Puma Energy, at paragraph 60 of that judgment, is a judgment of both the Chief Justice, the Deputy Chief Justice, and Justice Smarts, and paragraph 60 thereof. I invite the court to go to paragraph 60 of that judgment. It said, it has long been an established principle under the common law that when power is conferred upon an office or statutory body, it is intended that the power should be exercised by that office or body and no one else. Lord Bingham, in his celebrated book, The Rule of Law, writes that an important aspect of the rule of law is that public power must be exercised only by those in whom the authority to do so is reposed. Paragraph 61, relying on a rally for democracy and progress and others, versus the Electoral Commission of Namibia and others, this court held that power must be exercised in a lawful way in a constitutional state. This requires that it must be exercised by the authority upon whom it is conferred. Unauthorized delegation is administratively invalid because it constitutes a usurpation of parliamentary legislative authority. If your lordship goes to page 116, the court will find Proclamation 34. And under Proclamation 34, I wish to emphasize what the President did. The President says at A, I have amended Proclamation 28 of 26 September 24 by extending the period of election of the President and for the election of members of the National Assembly referred to in that proclamation from, crucially, 21 hours on Wednesday, 27 November 2024 until Saturday, 30 November 2024 at 2100, subject to Section 93, subsection 3 of that Act. The President has no power, had no power to extend the election on the 27th of November at 9 o'clock as he purports to do. That power rests with a presiding officer. Any vote, therefore, cast as a result to answer to Justice, to the Deputy Justice question when the illegality arises is at the time that this proclamation is effective from. To the extent, and just to conclude, you will find at page 46 of the bundle that of the record, page 46, is exhibit is Annexure B. The court will also find a directive, and also an illegal directive by the ECN directing all polling stations to remain open on the 27th of November from 9 o'clock. That takes us to the narrow remedy we pray for, that absent, and this fits in with what we submit is a concession not 9,000, my lord. And this is what the what the Electoral Commission does not do. It does not. It only takes into account the votes cast on the 29th and 30th. Those are the votes that your lordship speaks to. It does not at all, despite them being aware that they have requested the president to act this unlawfully, and if I may take your lordship to that paragraph, I think that yes, if I may, the ECN does not deal with the votes cast that are caught by the Proclamation 34 at 9 o'clock on the 27th at all.
They said there was no election, no voting.
No, they are saying that with respect to the 28th, my lord.
No. Well, it's paragraph 83 and
yes, my lord.
Paragraph 93 in relation to LPM affidavit. They said there was no voting.
No, there was no. They are saying there was no voting with respect to the 28th, my lord. I am speaking about votes that was cast. There is no debate, even on ECN's own version. There were votes. On ECN gives you two versions here.
Those votes from 9, are they not taken care by 93 itself? They didn't have to issue that directive. 93 takes care of that. They could stand there until midnight. 93 takes care of that. That's how I understand the act.
Yes, my lord, this is a threshold issue, a factual issue, and your lordship will search in vain for a confirmatory affidavit by any presiding officer to that effect. What your lordship will find to the contrary is that the ECN itself says, President, extend the vote from 9 o'clock on the 27th. And I just want to get your lordship to that.
My lord, I must record on behalf of my client the objection that everything that is now said in the reply is new. It's not been dealt with, and I record that with respect.
Your Lordship, also in respect of what Justice Damaseb and Justice Mainga said, without there being a response on the 28th, the fact on the papers is that there was no voting in terms of the proclamation, except those who may have been voting in terms of Section 93, subsection 3. In other words, they were in the queues by 21 hours on the 27th. So they could go over, but they are counted as having voted on the 27th because they have the right to vote, say, next day at 7 in the morning. What is my colleague doing with respect to these new things?
If I may take the court to the ECN's own affidavit, it's page 765, paragraph 16, page 765, paragraph 16, the ECN itself says this. I have already explained in the Commission's affidavit in answer to the IPC case that the Commission resolved to recommend to the President that the polling period be extended from 2100 hours on 27 November 2024 to 2100 to 2100 on 13 November 2024. That is on Plascon Evans what you must accept. That is the extension, and that is why we say that is caught by Proclamation 34. As to the Deputy Chief Justice asked where we get the stats from. The statistics on Swapo's support. Yes, your Lordship will find that at paragraph 137 of our finding affidavit. Page paragraph 137 at page 637 to 640. As it pleases the court.
With leave of court, that statement that when I corrected my colleague, it's exactly at page 283, paragraph 94, which explain everything, including the fact which, therefore, there was no voting on the 28th of November, except for those persons who voted pursuant to the provisions of section 93, subsection 3. Everything is addressed at that page, 283.
Well, that invites the question, then what was the purpose of the extension?
Well, we can debate and debate. I know, Mr. Kurtz, you want to rise again.
I don't know whether the court would wish my junior to email the lists of the 25 and the 11. I'll leave it in that court's hands. Whether you want the list of which 11 polling stations do appear as the schedule to the original government notice of 305 and which 25 don't. I think you just about finished it.
Well, the documents must be served. It must. Yes. I thought we agreed you were going to provide us with those documents.
We'll do it in the next half hour.
Yes.
As
what does he want? What does he say he wants? That's fine.
Your Lordships,
Mr. Narib.
we shall have to respond to that list once it is provided. That was not the case. They pleaded. We did not have the names of the...
To be served on all the parties, except that I don't know how we're going to deal with these factual issues again after having. Do you have to recall the court and hear arguments on that, or we can deal it on the basis of papers? What?
A quick suggestion.
Yes.
We'll supply the document. If we're right, the court will take, and then the respondents can say whether they agree with us or they don't agree with us. If they agree with us, the court will take that into account. If they disagree with us and they show that we're wrong, we'll leave it. But I do think it's important that the court...
This hasn't been pleaded with any specificity, so that an important party to these proceedings hasn't been afforded the opportunity to deal with what has emerged as a serious allegation towards the end of your argument. It hasn't been prominent in the papers, except for that one paragraph, without any specificity. Just speaking for myself, I've got grave difficulty with matters coming before the court like this.
I did this morning mention one particular polling station. I said, as an example, here's a polling station that doesn't appear. I think it's the number 2 on the...
There could have been an explanation for these places that could have been put up under affidavit by the Commission.
I accept that. But I just think that it's not inappropriate for the court to at least... it's a very serious thing when the President and the Commission tell the court that all 36 stations are included in a schedule when, as a matter of fact, they're not. There might be an innocent explanation, there might not be. But I would think, speaking for myself again, it's a very serious situation that has arisen. And I don't think we can just sweep it under the carpet with respect. But I'll leave that to the Chief Justice and the rest of the bench. And I can't take it further.
Thank you, Mr. Katz. We've taken. Well, we have come to the end of the very long day, and I wish to express the court's thanks and appreciation to counsel for the assistance that you have given us. Well, in terms of the law, we must render the decision within 14 days. 14 days, I believe, from the date of the hearing. And so we'll take time now to consider the submissions and the entire case before we'll be in a position to hand down judgment. We expect that we should be able to hand the judgment by the 28th of February, if I calculated correctly. So that's it. Yeah. Well, thank you so much, Counsel. And now we've come to the end of the proceedings. The court will now adjourn. The judgment is reserved.